Politically Speaking. With me, Tarun Nangia. Today, we're going to discuss the all-important topic of entry of foreign law firms in the Indian market, which has now been allowed. I have an eminent panel who joins me today. I have with me Senior Advocate Percival Bilimoria. I have with me Malak Bhatt, Senior Partner with NM Law Chambers. I have with me Sarosh Zaiwala. Now, I want to tell you a story. He's the first Indian who went to UK more than 4 decades ago, started an Indian starting a law firm in the UK and successfully is running in for more than 40 years. He will give us a global perspective. Welcome all of you. And at the outset, may I request Senior Advocate Percival Bilimoria to make the first few comments on this issue before we move on. Over to you, Mr. Bilimoria.
So, Tarun, a little belated, but we at least have a first step. But I would like to just add that it is a very slightly nebulous first step. There are a lot of regulation which are, not clear. Also, when you say opening up, we must be a little cautious there, because a foreign lawyer or a foreign law firm can register with the Bar Council, which is a first, and it can only practice foreign law or the law of the country where the firm or the individual originates from and is licensed to practice. Now, this, of course, raises a very important question, which is if there are multi-jurisdictional firms. And remember, the other condition is reciprocity. Now, what does that mean? I mean, you have the example of Sarosh, as you said, he's been, an Indian who's gone there and practiced for, quite a few decades, actually. So some jurisdiction like UK, they have always been open. Today, you can set up an office in UK and practice. There's no holds barred. But there may be some jurisdiction where you cannot do so. So when you have global law firms which are multi-jurisdictional, what happens there? How do you apply that test? I think also the biggest issue really here is you cannot have a situation where a foreign law firm sets up in India and then engages Indian lawyers who will then have the opportunity to work in a global firm and practice Indian law. That is not possible yet. But we look forward to this as if it's the first step towards a much larger canvas where foreign law firms can come and compete in the Indian market on equal terms.
Okay, so this is the first step towards a larger canvas, is what Percival Bilimoria is saying. I'll go to Malak Bhatt, partner with NM Law Chambers. Malak, your first comments on this big decision.
So I completely endorse Percy's view here. See, if you look at the backdrop of how this comes about, we've been seeing this being raised in various courts time and again. 2018 is when the Supreme Court touched upon this and left it to the Bar Council of India to actually frame rules. So this is the case of A.K. Balaji, where the court really touched upon the fact that we have recognized the fact that there is an era of globalization which is taking place in the legal fraternity. How do we tackle that? We as the court may not be able to get into that. We recognize the fact that foreign lawyers will fly in, fly out for the purpose of arbitrations. But ultimately, it's for the legislature or for the statutory body to come up with proper regulation. So in that context, if you see these 2023 rules, it is definitely a recognition of the fact that we are now recognizing foreign lawyers and foreign law firms to partake some amount of legal work in India. It is absolutely right that today the way in which the regulations are made leaves a lot of room for doubt in the manner in which they will actually be able to function. So if you see, let's take an example. If you just see the requirements of registration of a law firm or a foreign lawyer in India, currently the rules provide a very onerous requirement on these lawyers or law firms to actually register with the Bar Council of India. You're supposed to give at least 10 documents, various undertakings, various documents from the authority, where the authority may not even be giving this document. For example, the UK does not, I know for a fact that the UK, there is no body in the UK which can give you a good conduct certificate to say that you have a good standing at the bar. Unlike a Bar Council of India good conduct certificate that we get here. I'm pretty sure that neither the INS over there nor any regulatory agency gives you that certificate. Now, without that certificate, how will a law firm registered in the UK come in? So there are various issues on that front. But what is fundamental and what is seminal from the fact is that you are today recognizing an international fraternity in the legal center to come into the Indian market, which is the very interesting part is that for the very first time, the Bar Council rules have recognized what an Indian law firm also is. Till now, there's been no definition of an Indian law firm. But because of the advent of foreign lawyers and foreign law firms, now there is a recognition of what an Indian law firm will constitute. And that today, according to me, is at least a good positive step in the right direction.
Thank you, Malak, for sharing your opening comments on this very, very important decision, which has now generated a lot of opinions in India all over. I'll go to Saroj Zaiwala, who's joining us from the city of London. Mr. Zaiwala, you are somebody who's a pioneer of sorts. You went to the UK over 4 decades ago, became the first Indian to start a law firm there, and are successfully running it for more than 4 decades. Your firm did some really high-profile cases in all these years and earned a name for itself. When you see this decision that the India is now allowing it, and it is happening ahead of the India-UK Free Trade Agreement, which is going to be signed soon, what are the first few comments that you would like to make?
First of all, let me make it clear that Zaiwala and Company started in London 41 years ago. But in Bombay, there has always been a Zaiwala and Company started by my father since 1926. So in 2026, we'll be having a century. I think it's a very, very welcome move, and it's going to be beneficial not only for young lawyers in India who are looking for international law practice, but also for India generally. India is going to be, in the next 2 years, the 5th largest economy in the world. And that's a great thing to happen. And that means there's going to be a lot of international trade between India and overseas party. And the most important thing is when parties agree to New Delhi arbitration or the English court, they would expect lawyers who understand their case to appear for them and to put the case forward. And that is something which will be achieved. I'm not too concerned about the restrictions now. Once the foreign lawyers come in, what my guess is that all the restrictions will slowly move away, because there'll be much more arbitration work for the Indian lawyers, because at the present for Indian government contracts, it's now going to Singapore, and Singapore allows everyone to appear. So why should Delhi not be, or any other city of India not be the center of international arbitration? So I would certainly welcome. So secondly, it would be a great encouragement for the young lawyers, because at the moment, put it bluntly, and I have respect for all of them, there are few law firms that monopolize the high quality international work. Now, if you allow the foreign lawyers to join hands, there'll be a lot of junior lawyers. In fact, I have received quite a few of these law firms from Delhi and everywhere saying, can we join hands? And why should that not be? They all must have an opportunity, no monopoly of anyone, and you compete. Look, when I started in 1982, there were no Indian lawyers, and everybody laughed. And I said, and there were law firms, but they were in the suburbs doing immigration and all that thing. And they put the name in English name, although it was Indian faces. And I said, no, I'm going to start with my Indian name. And the judges used to be confused how to pronounce Zivla. And today we are doing international law work. Now, this would not have happened if there was any restrictions on the part of Britain. And I think at the end of the day, merits must prevail. Even if the foreign lawyers come and they're not good, they will be rejected. But it will give opportunity for our Indian lawyers to also understand. See, today, let us see. There are Indian advocate who has joined the bar, like Harish Salve and all. So why should a foreign lawyer not practice here? It's on the merits. And now what we want is the arbitration income to come to India as a center. Otherwise, India has a contract with any any other country. They will say, no, we don't trust your arbitrators, we don't trust your court, it'll be delay. So it will help attract the investors into India. So I certainly think it's a good beginning. I welcome it. And the Indian law firms should not feel at all scared by it, because I'm sure they are of high level, as the Indian have tremendous good intellectual mind, and they'll be able to compete with them. And they will also, if they get to know the foreign lawyers, they'll also have an opportunity to go there and open offices there.
Thank you so much for your comments. And now senior advocate Percival Bilimoria is somebody who already does a lot of international arbitration. Keeping that in mind, could you share your opinion with us? What is the good influence that will happen when foreign lawyers can come and appear in arbitrations here? Can you give me a holistic view of, because these decisions have a great impact, what impact will it have on the Indian arbitration ecosystem?
Impact also on the country, India as a whole.
Not much. And I'll be very honest here. Until the rules are further refined, I think the answer is not much. I'll tell you why. Look, if you set up just a pure arbitration chamber in India, now the point is that even if you are an Indian qualified lawyer working with that arbitration chamber in India, that chamber, even that Indian lawyer cannot litigate. So what if there is something that emerges out of the arbitration, an award or an interim award, which needs to be challenged? You do have court supervision over arbitration process. What will happen? They'll have to go to another firm. It's not practical, right? Or let me put it this way. Let's say there is a firm here which is registered, and will another party from abroad, will their client go to another party from abroad saying, look, we can't litigate here, so therefore why don't you come and brief another lawyer here and litigate? So these are some of the issues that have not been thought through, I'm afraid. So I don't think it is going to make a sea change. Also because, please remember, as per the Balaji judgment that Malak spoke about earlier, arbitration fly in, fly out is allowed even today. Nobody is really prohibiting that. Please understand that one of my long-held views is that by preventing foreign law firms from coming to India, what is it that you are achieving? And I'll tell you why I'm saying this. The foreign law firms who are not in India today are in any event doing work in India with Indian clients. As far as arbitration goes, they are already involved in arbitration on Indian law documents. So this is not something that is new. It's not going to be such an incremental jump for them. On the contrary, by setting up in India, they are going to be in a position where they cannot litigate. So it's I'm frankly disappointed by this. It's not also on the corporate side. I don't know. I would like to ask this question: how many people are going to queue up to come to India? It may be that there are certain multinational firms who want to be able to show, that look, they have an office all over the world, and now India's opened up, so they have an office in India. Face value does count for something. It gives comfort to the client abroad that, okay, you have an office in India, somebody who knows the lay of the land, who can navigate the matter that's carrying on in India. But that is cold comfort. These offices will be very thinly manned. Until the restriction on Indian lawyers and foreign lawyers working together is modified, you are not going to have a true multi-practice law firm in India.
I'll take that to Malak Bhatt from NM Law Chambers. Malak, can you give me what is the Indian perspective on this, in the sense that in arbitration, what will happen in M&A, and of course, they are now allowed to practice. There is some hesitation, of course, on the Indian side. Why do you think where that is coming from? Is there a fear of losing business? Could you clear up these points?
I just take it from where Mr. Bilimoria left it. If you see the statement given by Bar Council of India immediately after these rules were announced, so there's in fact a clarification which is issued, which says we'll clarify that the foreign lawyers can only practice or give advice with respect to foreign law, nothing to do with Indian law. And the statement categorically says that we are going to ensure that the interest of the Indian advocates are not jeopardized. So there is some incongruity in the fact that the rules have come in, qua the statement which has come in, because it does not seem that there's an event to promote the interest of Indian lawyers or to promote a globalization of the legal fraternity as a whole. That statement kind of runs contrary to the fact that the rules have been taught. Number one. Number two, most interestingly, is there's a disadvantage placed in the rules for any lawyer who stands recruited with these foreign law firms. It says that if you get recruited, as Mr. Bilimoria pointed out, not only can you not practice in the Indian courts, you will be at a disadvantage as compared to your peers who are practicing in an Indian law firm or an Indian legal setup solely with a domestic firm. So at some point, it is counterproductive, yes, to the extent that Indian lawyers may not want to jump gun and join a foreign law firm. Number two, the entire ambit of the rules is completely silent on any kind of partnerships or collaborations between an Indian law firm and a foreign law firm. Now, the idea of bringing law firms to the country, and we've seen this practically spanning out also, is that a lot of times we see best friend relationships. A foreign law firm always has a best friend firm in India till the time the rules came in. And the idea of the rules was to then allow them to set up an office in India so that an active collaboration could take place. This should not have been and ought not have been restricted only to arbitration, because arbitration was always there. The idea, if it was to garner more international expertise on various fields, leave apart litigation for now for a minute, but even on the transaction, on the commercial side, then the kind of restrictions built into the regulations today, at least, is a larger embargo than it should have been. But I feel that issue definitely needs streamlining. And the last issue that I'll flag before you take this to Mr. Sarosh, and that's one thing where his expertise may also come in, is that most jurisdictions which are developed on this front where international law firms are allowed recognize dual and multiple qualifications. So we have a lot of dual qualified lawyers who are allowed to practice in more than one countries. Will India or the Bar Council at some point recognize that you will have lawyers who will be qualified in Indian law as well as foreign law? We've seen a lot of our own peers, our colleagues, go to London, go to Singapore, get dual qualification and come back and practice here. As dual qualified lawyers, will they then be allowed to practice in collaborations like a foreign law firm with an Indian law firm, or practice both laws here? Because that's the entire achievement that the rules were trying to seek, which today at least they're not seeking.
Okay, I'll take this to... Yeah.
Quick clarification, or to put it differently, in the same example that Malak mentioned, an Indian qualified lawyer goes abroad, acquires a UK qualification and comes back. When he's registered in India, will he be able to register as a foreign lawyer, or will he be counted as an Indian lawyer?
Point well taken. I'll take this to Sarosh Zaiwala. When you see all of this...
Can I just please answer the latest point? An Indian lawyer who registers himself a barrister does not have to qualify again, depending on his standing. He could be enrolled at the bar, like Harish Salve and two or three others who have come in. The most important underlying factor we must keep in mind as Indians, that India today requires investment, is growing. And a foreign investor would want to bring his own lawyer to advise and to take charge of the situation. I think that is a fundamental reason why India thinks it is necessary to open up to foreign lawyers. The other thing is that it will all settle down. Only good lawyers will succeed and the bad lawyers will fail. So if there's a good competition from the top Indian lawyers, I believe that the Indian mind is very sharp. Look at Falina Rehman, Saudi Sarabji, Anjaru Jina, everybody around. So it will all settle down. So there's no need to make a fuss about it. Let everybody come and practice, keeping in mind professional restrictions for qualification, because they must have conduct rules. More than a law, they must have conduct rules, how they must behave. I think it will be open, and not just lawyers from England, but other jurisdictions can also come. If I'm a contractor and I'm going to invest 100 million, and then I hear about it, if there's a dispute, it'll go to court, and the court will take 20 years or 15 years to decide with all the appeals. They will not come, so we are restricting them from coming. Similarly for the arbitration, international arbitration. If you allow foreign lawyers to come, arbitration will move so quickly. I can tell you because I have appeared myself on many occasions in Indian arbitration. And the arbitrators they're all retired judges, they are very clever, but they conduct the cases like it's a law court, adjourn now, adjourn this. In London, we do not do that. In most of the Singapore is not done. Decisions are taken, awards are out in 3-4 months. And that is possible. Now, so the whole thing, or the scheme in Indian mind will change. And I have an eye on the young lawyers. So look at the young lawyers which are coming from India to London. Every law firm now has an India department. And there are 3 or 4 Indian lawyers in all this mega firm. They have an opportunity to come. They have an opportunity to be international. And the importance of internationality is that then you have combination. And please keep in mind that the duty of a lawyer is to ensure that the law is interpreted on the principle that law is for justice and not justice for law. And so it is, and that is what is changed now in England also. You don't say this is the law, but the law should be applied. And my firm has handled so many cases where this point has been taken and it succeeds. So I certainly think that 2 more main reasons why it's good for India. One is to make India's investment into India very attractive, because the investor will have a safeguard and he can appoint his own lawyers to advise him. And on this issue of that foreign lawyer can only advise on Indian law, I think that's too technical. And my feeling is that it will go on for some time, and after that, that rule will be abolished. Because today is one world, one mankind, and we all have to work together and get justice for the parties, not necessarily look just at our pocket whether we'll earn or not. So I think it's a very welcome thing.
2 points I took out from the many points that you've given. First, the foreign company, when it comes to India, might want to get its own law firm. That is point number one. Point number two, of course, arbitration in India taking far too long. It is not uncommon to get a date after 4 or 5 months sometimes. And that shocks a lot of people that for a process that should be completed within a year, if I get a date after 4 months, what happens? I'll go to senior advocate Percival Bilimoria for his comments that do you think at least in the non-litigation space, should there have been a full allowance of foreign law firms to practice in India for the arbitration system to improve greatly?
First of all, I agree with Sarosh. It is a good thing and it is a very good first step. But you see, the rules are not really amenable as they stand today, because Indian lawyers cannot advise on Indian law. So, for example, if you're doing a transaction and it is the foreign law firm registered in India which is doing a transaction, that foreign law firm cannot advise if it's an Indian law document as per the current rules. And any Indian lawyer which is hired by them also cannot advise on the Indian law document. So this is that distinction between what is an Indian law document and a foreign law document. Yeah, I feel that, perhaps foreign investors in India will be more tempted now to perhaps transition towards making these documents subject to foreign law, which is an oddity because remember, the joint venture company that you are setting up is going to be in India. So it must necessarily be governed by Indian law. That's been the traditional thinking so far. Foreign companies coming to India do not mind entering into Indian law document. That's a very big issue here.
May I just interrupt you and say, yes, if that is the rule says that a foreign law cannot advise on Indian law, or an Indian lawyer working in a foreign law company cannot advise, then I think it's not a practical rule.
That's the issue that I'm pointing out. So it is desirable.
What will happen is it is not a practical rule, and when there are unpractical rules, people will the lawyers themselves will say it does not work. The government will notice it, Bar Council will notice it, and it will sort of ease itself. So let's make a start and see how it goes.
We have made a start, so let's
go. Excellent.
Goes in the right direction.
I'll take this to Malak Bhatt from NM Law Chambers. Malak, Mr. Zaiwala said when foreign law firms come, they will get, when foreign companies come to India, they may want to get their own law firms to advise them. There is a comfort level. They have to work. Do you think there is a hesitation in the Indian legal practitioners market of that they feel that they may end up losing market share? What is the reality is a different point. We are talking of the hesitation do you think there is or there could be?
Well, if I have to put this very candidly, let me tell you that at least on the younger generational front, I don't see that hesitation there, because on a more philosophical level, it's the experience of the foreign law firms that people are really looking forward to. See, there is no doubt about the fact that wherever you go today, Indian lawyers are the ones who are actually thriving, even most of the foreign law firms that we've seen. And if I talk about my seniors from college, the peers that I've been working with today, some of them are even heading India practices at bigger White Shoe or Magic Circle law firms. So it is ultimately going to be your own competence, your own hard work, as Mr. Zaiwala said, which is going to work out. What Indian lawyers are really going to gain from is the fact that a foreign lawyer or a foreign law firm which has an international repute or an international practice experience is going to get that practice onto the table for you to be able to be part of that globalized world. And once you have that platform within the domestic field of the country, it definitely will create a huge impact, not only in the arbitrational front, but definitely on the transaction on the corporate front, which I agree with him to the extent that it's a great step. Yes, it will require a lot of streamlining, but I don't see a hesitation, at least in the way the entries is being thought about right now.
So the younger lot, you think, is all for it? They will and they'll be enriched by the global practices that these foreign law firms bring.
Absolutely.
May I just give a bit of piece of information? The longest ever address to the Supreme Court after independence was Sir Dingle-Foot. So after independence, English barrister did appear in the Supreme Court, and that can be checked. And sooner or later, it disappeared. So there's nothing wrong. People, sorry.
No. Please go ahead.
So it is, what will happen is that once a foreign law firm comes, international standards will be maintained. And I have in mind that in 2 or 3 years or 4 years, we are going to be the 5th largest economy in the world. Now, when we are a big 5th largest economy, we can't keep these rules. You can't come here. You can't do that. Every human being has a common sense. They have to appear, even all lawyers have to find a common sense way of approaching. And I think this is the start which has been made. We welcome it. I hope there will not be further rules restricting it. So I noticed that some of the law firms have asked the rules there should be further restriction. I think it will all play off. It will all work out. The competent people, Indians and any other, they will survive. The incompetent might find it difficult. So we must allow the merits. And today, as I said, there's so many young Indian lawyers. They're asking, can we join? Can we join? And we should encourage the young team. We should look at the future of India.
I'll take this point to Senior Advocate Percival Villimoria. I want to ask you 2 things. In about 2-3 lines, if you could share with us. A, does this opening up amount to much in your view? B, do you think that at least in the non-litigation space, everything should be opened up? Litigation can still be kept for later sometime.
Look, on the first question, yes and no. Yes, because it is a very important first step. And it is long overdue. But I guess the question I'm asking is, if you were a foreign law firm, today you can hire an Indian qualified lawyer, create a team sitting in Singapore or London or Dubai for that matter, and that team is in charge of the India practice, and that team can advise clients on Indian law. So why would that foreign firm set up here when after setting up here, they cannot advise on Indian law?
Good point.
That's a problem. So therefore, there's the response. I'll be very interested to see how this plays out. But this is going to be a little bit of a hiccup in the beginning. That's one. As far as arbitration is concerned, today, even without this regulation, arbitrators can come in. Balaji says that. You can come in if it's an Indian law document. Also, foreign firms can come in an international commercial arbitration. The definition of international commercial arbitration in these regulations is very similar to the Act, which is that one or the other of the parties is domiciled outside India. But so there's a transaction between an Indian party and a foreign party, and that goes sour, so you have an arbitration. But the point is, are you arbitrating an Indian law document or a foreign law document? If it is an Indian law document or a foreign law document, the foreign firms are anyway participating in that. So therefore, what changes? What changes is, by setting up here, you are not going to be able to challenge that in a Section 34, for example, or there are various provisions in the Arbitration Act where you can call for supervision. Arbitration proceedings are carried on under court supervision, although courts are not supposed to intervene too much. But court supervision does come in at some stage or the other. Section 9, Section 34, 37. Now, if there is an Indian office of a foreign firm which is involved in an arbitration, and that particular arbitration requires one or the other of the parties to go to an Indian court, right? Then what happens to a completely new team takes charge? So these are the practical issues that we have to think about. And as Saroj said, I'm sure it will get ironed out, because somebody somewhere is going to wake up and say, hey, this is something which is a little bit of an issue. Let's see if we can sort it out.
Interesting. China has allowed entry of foreign law firms. Vietnam has allowed entry of foreign law firms in their market. So India is doing it after all these countries. We'll take a round of final comments in 30 seconds each, because we are out of time. We'll start with Malak Bhatt of NM Law Chambers.
Yeah, so my parting comments again, twofold. It's definitely an incentive for law firms. It's an entry barrier which has now been lifted after a long time. One fundamental flaw, as I stated in my first comment also, is it is not incentivizing Indian lawyers to join foreign law firms as yet, because you are not allowed to practice in courts, which is a huge barrier for Indian lawyers to join such foreign law firms as and when they set up their offices here. That definitely will require a lot of thinking around. And the second part is that the restriction placed on the foreign lawyer to only advise on foreign law, that too, and keep in mind the restriction under clause 8 says you can only advise on foreign law pertaining to your primary qualification. So restriction which otherwise will not exist on him in the jurisdiction where he's otherwise practicing is today placed here. So again, this will require a deliberative table between the law firms and Bar Council, but I'm sure it will reach some headway.
Okay, I'll go to Saroj Zaiwala for his closing comment.
You gave an example of China, and I don't know whether you know, but my firm was the second law firm to open office in China after Clifford Chance, and sponsored by the Chinese government. To that time, there were no law firms. So, but today, China has absolutely top quality law firms, Chinese partners, all qualified in Harvard and Oxford and Cambridge, and with huge offices. So they have grown. It gives it, and the young lawyers, they've all gone. In 20 years, 25 years, they've all gone up. And I think this is what will happen, that once the foreign lawyers start coming in, there will be competition. There might be a few people who might not like it. But at the end, we Indians should not be scared of having competition. And this is what I would say. So I think it's a welcome first stop. And I sincerely hope that the Bar Council does not put hitches and makes it difficult. There will be laughing stock in the world. So let's keep the foreign lawyers as it is now and then progress and see how things go on. And it'll automatically go well.
Okay. I'll take this to Senior Advocate Percival Bilimoria for his closing comment.
So, Saroj, I don't see the rules getting more stringent. If anything, as a first step, they'll only become more liberal. So that's, I think, in that sense, it's a very good first step. It's long overdue, but some of these little nits have to be ironed out. Now, let me tell you the Indian lawyer's perspective here, which is that, look, it has to be a level playing field in the sense that today in Indian law firms, they have restrictions on, let's say, promotion and advertisement. So there are certain regulations in the manner in which Indian law firms operate, which are very different from the way you guys operate. So Indian law firms should have that ability to compete on a level playing field. And I think if that happens, I don't see anybody really minding.
Okay. Point well taken. Appreciate all three of you joining us today. Saroj Zaiwala, Managing Partner Zaiwala and Company, joins us from UK, City of London. I have with me Senior Advocate Percival Bilimoria and Malak Bhatt from NL Law Chambers. Thank you. Appreciate you joining us. Thank you for making time. Thank you so much.
Thank you for inviting me. It's a great honor.
For more such videos, subscribe to the NewsX YouTube channel, hit the bell icon.